it. Application has been registered, but it isn't getting listed.
Post it week after next. Week after next, all right? Week after next, after 2 weeks, all right? Okay, great. Take that.
Memo for withdrawal.
Withdrawal. A very happy thing for us. Take it tomorrow.
May I pardon? To interact.
Why you are not happy with the court, or just any settlement has been done? Settlement.
Two interpret appeal. One is regulation of a class 4 employee service, and another is the rehabilitation assistant appointment.
Why is not on mic here? Put the voice on mic. Mic is operating.
Two interpret appeal. One is regulation of service of a class 4 employee.
Which year?
2024.
24.
Yes.
Call week after next. Yes. Week after next.
Another
Whenever you are mentioning the matter filed by the other side, inform them.
Inform them. Otherwise, they will seek one more adjournment.
Even withdrawal. No, we don't seek an explanation, sir. If you cannot follow, just informing you.
Absolutely.
My lord, this is a fresh matrimonial appeal, man.
Matrimonial appeal. Okay. Week after next, we can take that. Very good.
This is matter of 24 matter. Of course, if I am not 24 matter, after the already filed by our Registrar General of High Court, after relating to the examination of distinguished, one of the competition of marking one with the paper. Ready for hearing.
Ready for hearing?
Yes.
We'll have it in the
No need of result after the
in the first week of July, all right?
Yes, that's possible.
Is it? You want early? Something. All right. Inform the other side also.
My lord,
first week of July, Lordship is saying first week of July.
First week of July.
Yes.
Not August.
Deep duration.
Very. First week of July.
my lord, late appeal of 2024, my lord. The service matter, the petitioner is out of service. He was in service for last 22 years.
22 years out of the service.
In service, my lord.
All right. We can wait for 22 days. All right. 22 years he has waited. Yes, take this.
My pattern in matrimonial appeal and for the wife also. Whereas the pleadings have been completed. Matter related to payment of alimony and the return of the gold ornaments. The decree has been passed way back in the 2008.
2008?
2008 years.
Yeah.
Matrimonial.
Call this matter. Next week, you inform the other side. Keep your client also there. And tell your friend to keep his client present. So that in negotiation something may happen.
No, this is a rate appeal this matter.
Which year?
24.
24.
Any date.
Any date. First week of July.
This person was employed in a aided.
2 weeks. 2 weeks. Okay. 2 weeks. 2 weeks. Okay.
That I was an employee in an aided institution. I was suspended, and later on, this honorable court had paused the suspension order. And a private.
When do you want, sister? When do you want your matter?
Next week.
Next week. Next week we have posted many matters. We will have it in the first week of July. All right.
Obliged.
Just remember, brother. Remember how many cases are posted in July. Okay? And clustering should not open. Spread over what you have.
Yes, I pardon to mention. This is a read appeal. In this case, I'm an option purchaser. Bank has taken more money but provided less amount of provided.
Taken more money, but in their accounts, they have
provided me less amount of land.
But how we can decide all these things? Anyway, second week of July.
In the read appeal number 237/2024 manner, relating to returning of document mortgage property.
Mortgage property. Mortgage is redeemed now.
Madam,
you have paid back the money.
Mortgage property.
Say in Orissa. I will try to learn. It is a very beautiful language.
ଆମେ ସବୁ ଲୋନ୍ ଆମାଉଣ୍ଟ ଦେଇଦେଇଛୁ ତାପରେ ବି ସେମାନେ ଅପସନ୍ ଲେସ୍ ଆମାଉଣ୍ଟ ସେମାନେ ଅପସନ୍ କରିଦେଇଛନ୍ତି ଅପସନ୍ ପର୍ଚେଜର ଅଲସୋ ଦେୟାର ଆଉ वी also paid money bank to.
You have paid back.
ଆମଠୁ ବ୍ୟାଙ୍କ ପଇସା ନେଇଛି.
All right. In the
ଅପସନ୍ ପାଇଁ ପଇସା ନେଇଛି.
In the second week. He has redeemed the mortgage. Documents have to be returned. Okay. There is one beautiful judgment by Justice. I don't remember, Allahabad judgment. Once money is paid, the mortgage is redeemed. and the mortgagee cannot retain the documents, bring that judgment. Mullah on transfer of property mentions about. Take that.
She's very dead, man.
Then post in the second week of July 2025. Yes.
My lord, item 41.
Justice Dhawan's judgment. Senior advocate Rajiv Dhawan is there, na? His father's judgment, very beautifully written. Yes.
Lord, item 41 is a matter regarding deed for admission. I am for the opposite parties. I have got the documents. Some various documents he has noticed as per direction of this honorable court. I want to get the counter by next week.
You inform the other side who is
Yes,
for the.
he is here.
So you agree for the adjournment?
Adjourned by 3 weeks.
Yes, two.
At the request of
2 weeks.
2 weeks.
2 weeks.
2 weeks.
2 weeks I have posted many matters now. You have seen
3 weeks.
no 3 weeks. At the request of learned counsel, at the request of learned counsel appearing for the
DIMT.
respondent.
Yes, ma'am.
Respondent. And with the consent of appellant.
Admission petitioner respond.
Petitioner.
Petitioner and us.
Okay.
Item 8, my matters come up suddenly. My lord, the client says to engage senior counsel, my lord.
You want to engage senior counsel?
Yes, my lord. The client is I feel for 2 weeks, my lord.
But it's a old matter, it is
I-
purposefully listed up to 10. So kindly be patient. We'll pass that order when the matter reaches.
When matter reaches, we will take. See that. Okay?
I may be pardoned to mention that.
We will not pardon you. You can mention in the morning, no problem. Tell.
Lord, rate petition number 21091 of 2024, service method. And the opposite parties are not settling the allowances of the petitioners, my lord, who
They
are
are,
members of Juvenile Justice Board.
Juvenile Justice Court.
Yes,
We will have it in the third week of July. Third. Take that matter, it's third week of July. Inform your friend also. Inform your friend that you have moved the memo. Yes.
May I be pardoned to mention, my lords? My lordships, I am on VC.
Yes.
Your lordships, item number 32 of today's list.
Bhavani. Yes, Bhavani.
Your lordships, on behalf of Mr. Gopabandhu Das, I am mentioning item number 32 from today's list.
32. You want it? All right, we'll give you.
Your lordship, after 10th,
When do you want that?
after 10th July, your lordships, the conducting council has undergone a surgery. So, requested
Do you agree with this proposal?
Yes, man, I have distributed. So I have against the applicants.
All right.
I have no objection.
Okay. With no objection, comma, on the request of learned counsel appealing for appellant, matter is adjourned by 3 weeks.
obliged.
Bhavani, we had to owe you a night. Yes.
I don't know one.
Yes, brother.
No instruction.
No instruction. What instruction you need? You are not going to cross-examine anybody in the court hall. On the basis of papers, you have to argue.
But he has been paying the.
Jit Mahanti, my lords. The matter has been instructuous, my lord.
Learned counsel appearing for the appellant company. Company is it?
My lord.
No. Company. Appellant company. In all fairness submits that in the long run of time, comma, the cause has become infructuous and therefore appeal be disposed of as such. First off, when appellant himself says this, comma, we cannot have an opinion to the contrary. First off, next paragraph. In the above circumstances, appeal is disposed of accordingly.
Record his name because it's not record. DP Sahoo on behalf of Satyajit Mahanti.
Big signs appearing on signs on behalf of signs. That's correct. You're right. Next paragraph.
7.
Why?
This appeal has been filed by members of the Bonus Suraksha Samiti, Pratappur Bonus Suraksha Samiti.
Samiti.
Yes.
Is it a society?
Against the order,
Is it a society?
My lord.
Registered society?
My lord.
registers.
Approved by the district forest divisional officer of Subarnapur.
My lord, my impletion has been refused by impugned order. Stated 15.
Impletion in the COPET, company petition, where it has been
My,
by the
by the company.
Impleading. Impleadment. Who are you? You are members of the society.
Banu Suraksha.
Society or company?
No, society.
Society. What was the action challenged? Whether society matters also will be subject to company matters.
My lord, briefly speaking.
Briefly speaking, we are asking
My lord.
how company petition is maintainable by the society.
No, my lord.
No.
Company petition is filed by the company itself.
Company itself.
And this is the Banu Surakha Samiti. And in that company cell, major 60 acres of forest land, reserve forest land, has been decided to be delineated in favor of the company.
The state land is sought to be given to the company. That you have challenged, that was challenged by whom?
By the Banu Surakha Samiti, which is registered
Vana Samrakshaka Samiti, Forest Protection Council.
Under the Forest Protection Act, that we are looking after 4 reserve forests, including this reserve forest, and we have already planted many trees there.
The question is, where did you challenge that? In which proceeding? I mean, the question emanates, I think, from my lord. Because that was the question. In the company petition, what is the scope of adjudication by the company court?
Who went to company court?
The company.
Company went to company court. Challenging what?
Challenging that.
Please do not disturb. Please do not disturb. That disturbs us. We may damage your next matters. Yes.
Challenging to alienate the company properties. Challenging the alienate to company properties, that is ABS spinning mill, which has been sold out by the liquidator, and the company is the auction purchaser.
Liquidator sold that property. In the company was ordered to be wound up. It was ordered to be wound up. When it was ordered to be wound up, just give the foundational facts to us now. When was it ordered to be wound up?
In the meantime, the company case has already been disposed of.
We are asking the date.
My lord, that has been.
Company petition was allowed and the company was ordered to be wound up. And in the winding up proceedings, the liquidator directed auctioning of the properties of the company which are part of the forest. That's your case.
My lord.
Now that when the company was granted this land?
This land was granted by IDCO.
Who granted this and when it was granted?
By IDCO, my lord. By Industrial Development Corporation of Orissa, statutory to the company.
IDCO is now no more there. It has been it has merged with OMC.
IDCO is there, my lord.
Industrial Development Corporation of Industry, which if it is limited, then it is only a company, corporation, government company under 617 of the Companies Act.
There is a special statute.
A special statute? Which is that? Local. Which is that under which statute this is forward?
Index. My lord, actually question when the land is
when the land was granted and who granted it?
It is granted by IDCO in favor of the ABS spinning mill, which is a Odisha government take-up undertaking company. In the year 1981, my lord.
1981?
My lord.
At that time it was a forest land?
At that time also it was a forest land.
Where is the material?
Material is available under Annex 2, my lord.
Page number?
Page number.
Take out number.
Page number 46, my lord.
46?
My lord.
Volume 46.
Look at volume 9.
This is This is a lease.
This is a lease, man.
Is it a lease cum sale or lease?
It is a lease in favor of the ABS spinning mill, government company, started by.
That's all right. Under Transfer of Property Act 499, only 3 transactions result into transfer of absolute title.
Right.
Sale, exchange, gift.
Man.
But lease is defined as transfer of possession coupled with right to enjoy the properties. How that can be transferred? Auction.
My lord. That is the sole question.
That's your question.
My lord.
What is it? Then
That includes.
which is that judgment, that Apex Court series of judgments came now? That Thirumal Pad.
T.N. Godavarman.
T.N. Godavarman, Thirumal Pad versus Union of India. Which is that judgment? There is a best book by Rutvik Datta and Bhupendra Yadav. Law relating to forest. In that, this is decided. That book you have to bring.
My lord.
T.N. Godavarman versus Tirmalapad Godavarman versus Union of India. It's a series of judgments. All judgments are compiled by Rutvik Datta and Bhupendra Yadav. Bhupendra for the forest minister, perhaps, center. In that, there is such a judgment. How this matter should be treated. That research you have to do and come before the court. Not like this. When do you want? When do you want?
My lord, question is, the company case has already been disposed of.
Company case is
not. Yes, my lord, for your information, my lord.
So where is the date?
Date disposed of on May 2022. And against that judgment,
that order referring to the CPC.
And against that judgment, that which has already preferred appeal.
Appeal is
that is in the list, today's list, item number 9.
Item number 9.
Mine.
Wait for that.
Then wait, letter. But this research has to be done. Why lawyers are not doing research? I'm sorry. I'm very sorry. I am not comparing this bar to any other bar. But where is the minimum research? Advocates do not appear even in matrimonial matters. 10, 12 years or more. Then how judges should work? And you are not citing any section, any statute, any ruling. How we should work?
I will.
Industrial infrastructure development. They may not be able to. No, appeal is pending.
Appeal is pending.
Anyway, in appeal you can make application. But this application will go. This application will go because main matter itself is disposed of. We cannot allow your application because main matter is not pending. You will permit you to make an appropriate application seeking your impleadment. What you call? You call that impleadment.
Inflation they're saying.
Impleadment. Inflation.
Impleadment.
Impleadment. In the appeal. Appeal. Challenge in this appeal is to an order of the company court whereby the impleading application of the appellant is negatived. First off. Learned counsel appearing for the parties. Both the sides are present.
I am for Union of India, OP number 1.
Appearing for the appellant in appreciable fairness submits that the proceedings from which the impugned order emanated have been finally disposed of by the order dated.
My lord, May 2021, maybe 5th or 6th. That will be available in that their appeal, government's appeal.
Order in May
5th of May
dated 5/5/2024. 22. First term. 2022. We are also told at the bar that against the said final order, an appeal today.
Company Appeal 2 of
2022.
COA number 2 of 22. This is 2 of 21. That is 2 of 22.
Yes.
COA 2 of 2022 is preferred and pending. First off, be that as it may. This appeal at hand would not survive for consideration in view of disposal of the main matter in which the application on which the impugned order is made was made. First off. Next paragraph. In the above circumstances, this appeal is disposed of as having become infructuous. Of course, reserving liberty in favor of the appellant to make an impleading application in a proper form in the pending COA number 2 of 2022. First up, in that connection, all contentions are kept open. All right. Okay. Ordered accordingly. Even to make that application, you have to see Godavarman, one of the judgments. I think there are hundreds of Godavarman judgments. All right. See that. It's a good book. The latest 3rd or 4th edition also has come. Yes.
Item 8.
You want to hear senior counsel in this matter? When do you want?
Weeks after.
Call this matter week after next at the request of Shri so-and-so appearing for final. No time will be granted.
The request will be called for the complaint and all records.
Since it's an intra-court appeal, there is no difficulty.
Okay. Registry to keep the record of the proceedings, original proceedings in the file on the next date of hearing.
Copied number 42 of 2003.
Sorry,
COP 42
2003.
Yes.
Item 9.
Yes. What is this state of Odisha, state versus union? Yes, brother. Who appears for the state? What is this matter about?
This is challenging is appeal under the 303 of the Company Act, wherein the impugned order, it is at Annexure 4. This is under challenge.
Page number you have to say.
Yes, thank you. Annexure 4 is page number
49.
From page 49.
What is this order about? Enlarge this.
A base spinning mill versus.
What is this order?
By this order, the company petition has been disposed of with a observation that Sonpur mill, spinning mill, which has been closed, that the exact finding is the contingency part of the land in this case belongs to the Sonpur community.
Better you place the entire order. It's a brief order because you don't pull out, one paragraph.
And that operating part.
So, because the facts, how the court has appreciated the facts. Page 45, Annexure 3 is improved.
Yes, ma'am. Annexure 4, page
50.
Go to 50.
Go. Yeah.
On the page 55, my lord, para 5. The agreement relied upon by the states does not provide for continuance of the part of the land. In this case, belongs to the Sonpur unit of company in liquidation. Could not be sold by the regions of an embargo cast by the Forest Conservation Act of 1980.
That was a forest land. forest lands. Then the same question arises, Godavarman arises. For you to make research now.
My lord, sorry to interrupt, my lord. Sorry to interrupt.
Yes.
But they let them serve a copy. We don't have a copy. Honorable made a party. Let them serve a copy. I also accordingly.
Give a copy to your friend, brother. Right? We will not make order.
In course of
But anyway, we will not make order. We believe that state will give a copy.
Learned friend is there for the
Okay, what is your stand? Union, you appear for the union.
Okay, number 1 CTC.
Okay, without copy you cannot say what is your stand.
Yes, we don't have a copy. That's why.
All right. You serve copy today itself. Okay, we'll call this matter when? We have to do some legal research, na?
Week after, my lord.
Week after next. All right. Call this matter week after next. At the request of learned DA. First off, he shall serve a copy of the petition. Petition, no? Appeal. Appeal. Along with all the annexes on the learned panel council representing the union, respondent union in the meanwhile. First one. All right.
Obliged, man.
All right.
Item 10. Worship, appearing on behalf of Sujan and Biswal, I am for the appellant. Worship, we are the workmen who have worked in the Konark jute factory for about 20 to 30 years. Worship, the PF and ESI are all pending. Worship, kind sympathy consider the matter and condone the delay.
What is the extent of delay? How many days? What is the reason?
Reason, Lordship, there was the order dated 13/12/2012.
13/12/2012 is the original order.
Original order, wherein this Honorable Court had directed that there is a CMT number 36 of 2011 is pending, where all the cases would be adjudicated. And finally, the case was dropped.
How many days delay?
Lordship,
591. 591. How delay is treated in company jurisprudence?
And defects you have not removed.
Lordship, yesterday I got the brief.
Yesterday you got the brief. You want 1 week time?
Lordship.
We'll 2 weeks we can so that.
And also examine the law, how the delay in case of company appeals is dealt with.
That you have to say, delay in matrimonial matter, delay in criminal matter, delay in labor matter, delay in service matter. There are some patterns available. If you see half a dozen judgments of the apex court, is it not? They vary from field to field. Therefore, just look into and come back. A Ramaya on Companies Act deals with this matter. There is way Ramaya, very huge book on company law. All right. Call this matter of 2 weeks at the request of the Net Council appearing for the appellant to address the office requirement and also come up with more preparation to argue the matter. See, fine, so yes,
So the Tullah on behalf of SM Biswal.
Percent is 7.
So a little bit difficult spelling, so you write it.
You write your spelling also.
That is all. I don't know the
11, writ appeal. The affidavit. Yes, brother. What is this matter about? State appeal.
If infracourt appeal arises from the FAO under Annex 2, where in the under the Education Act.
FAO against, I think the writ appeal is not tenable.
There are 2 decisions. One is Prasanna Kumar Sahoo of our own High Court, as well as the Saraswati versus Vasant in the Karnataka High Court. In this special
Saraswati. You have identical
matters.
Okay.
But recently, what I gathered information from my government, it has been referred to the larger bench.
Yes. Decided. Yes. Saying
larger bench are decided.
Not maintainable.
No, Justice Deepak Mishra, Justice Arun Mishra judgment.
Recently,
They refer to the earlier judgments and they have settled it.
Mohammed Sahoo, that
Nothing remains.
Not maintainable.
so look, can you look at
This appeal is not maintainable or writ appeal is not maintainable? FAO.
First appeal against court.
First appeal. That was under 227.
227.
Therefore, no appeal.
you'll also kindly see the judgment. I'm glad.
What is that? We have understood. We come after reading all these things. They are taught to us in the law school. Berkeley. This intra-court appeal by the state is against order dated.
It's dated 11/1/2024.
11/1/2024, rendered by a learned single judge of this court.
Judgments of this court have decided.
Now, because rendered in writ petition number, FAO number
602 of 2019.
602 of 2019. Rendered under the provisions of Orissa Education Act. Rendered under section 24 capital C of Orissa Education Act 1969. First up.
It is arising out of that GI.
No, next paragraph. Learned counsel appearing for the respondent employee submits, and learned AGA appearing for the state is not in a position to much dispute that intra-court appeal of the kind is not maintainable in view of a full bench judgment of this court in writ appeal number 2047 of 2024 between Labha Kumar versus state and others, disposed of on 17/12/2024. First off. Next paragraph. In the above circumstances, this appeal is disposed of accordingly, reserving liberty to the appellant to explore other proceedings in accordance with law. First off. In that regard, all contentions of the parties are kept open. All right. What will be the other proceeding?
Definitely SLP.
No. Suit. Dhulabai versus State of MP. AR 1969 Supreme Court, page 78. Even if lawyers have written 227. So 227 is a supervisory order. No appeal. Appeal. FO is over.
Clear. And there should be a limitation that for indefinite.
Other thing. Therefore, we kept all contentions open. We will not say anything more than that. Yes. Yes, we turn it to this one. There are no report of this one?
Yes, it's already reported.
The report is what?
25. Volume 1 OLR. Page exactly around.
Okay. You tell the page number.
Yes, yes. Just
okay. All right. Okay.
25 1 OLR.
It must be reported in ILR also. ILR cut.
ILR, but OLR also.
OLR
Yes,
Part 1
state.
Okay. Dhulabai was the state of MP. 1989 Supreme Court, page 78. 68 Supreme Court, or 68 or 69 Supreme? 69 Supreme Court. One of the best judgments when suit is maintainable, when an order is suffered under the special act at the hands of special tribunals. That's okay. Appeal was provided.
Yes, sir.
Appeal you suffered.
Yes.
That order you challenged before the learned single judge. Other side, other you are responsible. Okay. Appeal itself was before the single. Oh, then Dhulabai does not apply. Because High Court's order cannot be set aside by a magistrate, by a munsif. On that
it has been confirmed.
Then only way is to take the matter to the highest court of the country. That's the only way. All right. Anyway, that judgment is very interesting judgment.
In other aspects also. That
other aspects also. Here, Justice Hidayatullah has laid down 6-7 postulates. It's a 5-judgment decision rendered under Section 9 of CPC. It's a very good judgment. Yes.
I don't well.
May I please?
In not properly evaluating the OMR sheet of the petitioner in National Eligibility Cum Entrance Test 2025, as per the final answer key published by the National Testing Agency on date 14 June 2025.
OMR sheet is not properly assessed.
Yes,
that's your case.
Yes, taking into account the final answer key published by the NEET.
Suppose if properly it was, have you served a copy on the other side?
Yes, yes.
You have served the copy?
Yes, so receive the copy, my lord.
His complaint is OMR sheet is not rightly looked into.
My lord.
Are you from some other place?
Yes, my lord. I am in the office. If my lordship pass over, I will come to the court.
Pass over. Get the request. Pass over. Just pass over. Okay.
Item 14.
There are 2 judgments of the apex court on the point which you have argued. How OMR sheet should be, the defect in the same should be adjudged by the courts. Bring those judgments. Go to library and please bring, that will help you. Okay? Kind of whenever we say, look into this, look into that book, don't mistake the judge. We are telling it so that it will help you. Is it not? Otherwise, we can pretend that we have heard you and pass some order. That will not do justice to anybody. Is it not? Just come with full preparation and come with your toolkit. Okay.
Item 14.
14. Yes.
It's a appeal section 370 to 1 and 3 of the CRPC against the order of acquittal.
Order of acquittal.
Yes, ma'am. This is my lord offense section 354D, 363, 376, 2I, N, 294 and 506.
Delay has not been condoned.
Delay has not been condoned. How many days of delay?
Delay is, my lord, 114.
114. You appear for the accused.
Yes, sir.
Will it condone the delay?
Yes,
This petition seeks leave to lay a challenge to the acquittal order for the subject offences punishable under the provisions of IPC 1860. First off, there is a delay of 104 days.
14 days.
14 days in filing the appeal. First off, application is moved and it is supported by an affidavit. First off. Learned counsel appearing for the accused opposed the application. We'll say that because your client should not mistake this. Next paragraph. Having heard the learned counsel for the parties and also having perused the application along with the main matter itself, we are of the considered view that there is a plausible explanation offered for the condonation of delay and therefore delay merits condonation. First off, in the above circumstances, this application in IN number so is allowed and delay stands condoned. You give one book to the library. Which one you will give? Give that Godavarman book. Godavarman. Law of Forest by Rutvik Datta and Bhupendra Yadav. Standard. The appellant to give one book to the Advocates Association Library.
Association Library.
Okay, latest edition or second or third edition. It's a good book, good compilation.
All the directions have to be
You also go through. We will also go through.
Get put it in 85 days.
85 days.
Look at the stamp report.
Then you go.
Just cross check.
Yes. Next.
I don't think
Before this criminal procedures. Criminal petition, section 378(1) and 2 of the SLAPC Milord.
How many days delay?
That is 77 days delay.
Brother, will condone the delay? Same order. 77. All right. Next.
Item 16.
16.
How
many days delay? Accused. How many days?
I want a small counter to the delay condemnation.
You want
the decisions, my lord.
When appeal was served on you?
Appeal.
Petition was served on you.
That is notice, my lord. On the basis of the notice, I enter appearance.
Correct. When notice was served on you?
My lord, I have enter appearance.
When you appeared is irrelevant to us. When were you served with the notice?
Before vacation, my lord.
Before it. Then under your rules, only 2 weeks are available.
My lord, I have read the affidavit, but I will argument.
Argue.
My lord. Here,
why delay should not? What is the number of delay? Reported delay?
240 days.
240 days. Yes, brother.
My lord.
Yes.
My lord, I have got 2 decisions, my lord. That is the Honorable Supreme Court. In the case of my lord, Office of the Chief Postmaster General and others versus.
It was not a criminal case.
My lord.
It was
a criminal case, my lord.
Criminal case?
Yes, my lord. And my lord, there, my lord, the procedural irregularities, my lord, so far as administrative part is concerned, my lord, that is dealing with an this Honorable Court in a case, my lord.
Give the
my lord. In a order, my lord, your lordship kindly see.
Yeah.
Postmaster General versus Living Media. That's a criminal case.
My lord, that citing that, my lord, in criminal case, my lord, this Honorable Court, the criminal law.
The Supreme Court decision is cited in all cases. That's a different thing. But you say that it's a criminal case. The lordship's query was very specific. That's what. Chief Postmaster versus Living Media.
My lord, what I'm saying, my lord, by citing that, my lord, a criminal case, my lord, appeal that.
Yes, we are with you. But you are citing a High Court decision.
And
which referred to that.
And one decision, my lord, by your lordship, though the fact is different, my lord, your lordship, I got my lord, sir.
Always.
In paragraph.
This we have seen now.
My lord.
The coordinate bench has ordered this now.
In paragraph, my lord, your lordship kindly see last paragraph, your lordship also can.
Keeping you, it was a case of 439 days.
My lord.
All right. Number 1. Then another judgment.
Another judgment by you lordships. That is.
That was a regularization matter.
Yes, lack of Shripad.
How that is applicable to criminal jurisprudence?
But my lord, I am citing that one para, my lord. There your lordships one para.
Where we refer to the
limitation, my lord. Why the law of limitation?
We said summons jurisprudence.
That's why.
Okay. Any other ground you have? This petition is presented by the state after booking a delay of 240 days, seeking leave to appeal against the acquittal order dated
10/3/2021.
10/3/2021.
Under section 376(2) NIP.
The respondent accused was sought to be prosecuted for the heinous offense of
376
offense punishable under section 376
IPC and read with 6 of postcard.
Read with section of IPC 1860, read with POCSO Act. First of all, there being delay, an application supported by an affidavit is moved seeking its condonation. First off. Next paragraph. First sentence. Next paragraph. Learned AGA come SPP. Are you SPP also?
Yes.
SPP. Yes. SPP. Submits that. PP. Submits that. In matters of the kind, ordinarily delay is approached with leniency, and it is more so when offenses involved are heinous. First off, he also submits that there is some merit in the petition, which may eventually turn to be an appeal should leave be granted. First off, lastly, he submits that the non-condonation of delay will result into an affirmation of acquittal order, which will not be in the best interest of the administration of criminal justice in the state. First off.
More so, Miller's COVID period is excluded. I have taken ground in paragraph 6 of my petition.
At paragraph 6 of the application affidavit, the ground of COVID-19 is also pressed into service. He cites a decision of Apex Court,
wherein 3 of 2020,
wherein it is held that COVID pandemic 19 to be treated as suspending run of the law of limitation, a run of limitation period pro tanto. First of all, next paragraph. Learned counsel appearing for the respondent accused vehemently opposes the application for condonation of delay, placing reliance on 2 decisions, of which one is rendered by this bench in WP number 11273 of 2024 between Kailasam P versus Karnataka Bank Limited, disposed upon
Chapter Karnataka. As a member.
A bench of decision of Karnataka High Court. Karnataka High Court. A report is available.
No. That is
live law.
Neutral citation.
Neutral citation, you can write that, na? 2025 KHC 7606-DB. Just look into. And a coordinate bench decision in criminal petition number 92 of 2013. The name and other things are not mentioned.
Well, that is mentioned.
Which case? Criminal petition number 92 of 2013.
మరి వెళ్ళడానికి ఏంటి?
That is on this. You will pay. Disposed of on 18 to 2021.
Cost title ଟା ଦେବା କଥା ନା ଆପଣ?
Cost title you have to give.
My lord, sir.
Fine. He also submits that delay is long and acquittal orders of the kind are ordinarily not loosely interfered by condoning the same. First term. Next paragraph. Having heard the learned counsel appearing for the parties and having perused the appeal papers, and also having adverted to the decision cited at the bar, we are inclined to grant an order for condonation of delay for the following reasons. A. Firstly, the delay has to be viewed leniently in matters like this, which involve acquittal of the accused for heinous offences. More particularly, when they are against women. Be seated. Be seated.
So that's kind of take your seat.
For sitting, what do you say, Noria?
Vasantu.
Vasantu.
Again.
Yeah. Secondly, condonation of delay does not add extra merit to the case of appellant against the interest of the respondent. First of all, what would happen is that the main matter would be heard on merit if delay is condoned. Thirdly, COVID-19 is treated in all civilized jurisdictions in the world as a ground entitling the litigant to the reprieve. First off, some courts have held that such a pandemic is a vis majore. First off. Fourthly, a plausible explanation is offered in the application supported by the affidavit seeking condonation of delay. First up, in the above circumstances, the present, one more second. The first decision of Karnataka High Court bank upon the counsel appearing for the accused is rendered in a civil matter and therefore may not be of much precedential value for a case arising under criminal jurisprudence. First off. The second decision of the coordinate bench involved a case having a delay of 439 days, whereas in this it is much less than that. First off, after all, judgments on condonation of delay or non-condonation are not treated as having precedential value, subject to all just exceptions. First, next paragraph. In the above circumstances, application is favored and delay is condoned. Which book you will give?
Lordship, please.
Huh?
Give me the cost title.
Huh?
That cost title in the CRLLP.
Yeah, you
provided.
Okay. Thank you. Okay. Subject to appellant presenting to the Advocates Association Library Roses in December by MC Chagla. It's a good book. Read it. There is some reference to delay also. All right?
Yeah. And that is the being of
typing. Yeah. Okay. Next. You also read that book, Roses in December. Though this is June, you can read it in the December book can be read in June also. Okay.
Item 17.
Excuse me, there is some delay.
How many days delay?
Delay I have not filed
Application not filed. You are for the appellate.
Yes, madam. In course of time, I will remove the defect.
But 3 years are over now.
Yes,
Huh?
yes, madam.
How? What is the nature of offense? Next.
I pray for 1 week after my read petition file is not available with read.
Not available to you. All right. Call after 2 weeks at the request of learned AGA.
Yes, ma'am.
AGA. He wants time. Yes.
I don't know. Filed as in.
Suggested date they will give you. Suggested date,
whichever date you want to send, they will.
My department discussed my learning senior that appearance. I am giving that appearance, my
Appearance.
Yes, my lord.
Appearance of Sri learned senior advocate is not taken.
They may be repeated costly.
Then we have done. We cannot dictate the judge should do. The order should be. We may be wrong also.
No, actually.
That's fine. That's fine. Yes.
Yeah.
Unutilized copy utilized.
One sentence.
One unutilized post widgets utilized.
Factor. We should make one standing order.
Yes.
Saying that wherever it is unutilized, it should be allowed to be utilized. Yes.
Let me please also. So, petition seeking by the state, my lord.
Yeah, take mic.
My lord.
Take mic. Otherwise, court may presume the weakness of the voice reflects the weakness of the case itself.
Right.
Yes.
Whether the state of my lord. Against the order passed against the acquittal order passed by the Lord Session Judge Decanal, my lord, acquitting the accused respondents under section, my lord, punishable under section 304B, 3042, 34.
Culpable homicide not amounting to murder.
My lord.
Gross negligence.
Not negligence, my lord.
Death by negligence.
Death by my lord, torture and subjected to death. Like cruelty, torture,
Or when I did capital A.
Cruelty.
This dowry death.
That.
What dowry torture and both?
How did it? It was
Full and beating.
okay.
You should have mentioned the thickness section on the last, gravest section first. To increase the code.
Yes, 498 capital A.
My lord.
Okay.
304B, 304, 34 of IPC, Railroad Section 4 of the DP Act, my lord.
Yes. This is for admission, it has come.
My lord. Issue has not come.
But they have appeared, my lord. How many witnesses were examined by the prosecution?
And there are
give the paper. Leave is accorded now.
leave is not
Leave is not yet accorded. We will grant leave.
my lord.
In a case involving the offences punishable under section 498 capital A and section 304B of IPC, an acquittal has been secured by the respondent accused. First one, state has preferred this petition seeking leave to appeal. First one, having perused the petition as well as the order which is put in challenge, we are of the considered view that this is a fit case for according leave. According leave. First one. Next paragraph. In the above circumstances, leave as sought for is accorded. First one. Registry to process the matter further. TCR to be called for immediately. Paperwork to be filed within 6 weeks. Within 6 weeks. Okay. Karnataka. The paperwork is prepared with the petition.
Passover matter, will you also look at?
Where you spoke over to the other side.
She has sent a message, my lord.
Saying? What is that 6/25 order? Well, that question will not arise. Different pitch. What is this matter, brother?
So grant of RSCP, revised assured career progression to the employees. Counting their service.
Revised
assured career progression. RSCP.
Revised assured career progression.
Like
it is like CAS.
Yes, that MACP.
That way.
That is at 10, 20, 30 years of service, that if they are not getting a promotion, they will get the benefit.
Instead of
financial upgradation. So not granting us the benefit of this RSCP, my lord, by counting 5 years of qualifying service we have, that has not been counted. That is the subject matter of challenge, and that has been, we approached the authorities and authorities have rejected that against the order, that order I have come.
Show it.
My lord. When we come to annexure 9, the first government order, address 34. They are the employees of this honorable court, my lord. The representation was considered and forwarded to the government by the special officer. It was decided. Shall I read them?
Yes.
Inviting a reference to your letter.
In inviting a reference.
Yes, in inviting a reference to your letter number 1366 dated
29
on the 2000. I am directed to say that Finance Department resolution that is 15 is not admissible to the ASOs who have been promoted to inducted with effect from 36/2008 from the ex-cadre post of copy speech. The period of SCP and RSCP will be admissible with effect from 36/2008 in the instant case. The clarification is to consultation with the Finance Department.
One second. We are processing. Will be admissible with effect from 30 June 2008 in the instant case. Why 30 June 2008, brother, government?
Yes. That,
my lord, because they joined as ASOs.
After that?
On 36/2000.
With effect from 36?
Yes, 36.
Then they were already on that day, they entered the service.
Yes. From 36/2008,
you joined afterwards.
No. They joined in other from ex-cadre post earlier. But in the present case, they were promoted, inducted with effect from 36/2008. So far as ASO post is concerned, ASO assistant.
Where is the policy granting this?
Yes, that is the guideline. They have annexed themselves.
Show that.
That guideline is
that shall I clarify the facts?
We'll come to you. We'll hear you.
Annexure 6.
Which paragraph, brother?
Page 23. And you'll also be turned to the next page. Annexure 20. I'm sorry, page 24.
24.
Page 24 is the revised assured career progression scheme. Paragraph 1 itself, it's very clear. There shall be 3 financial upgradation under the RSCPs counted from the direct entry gradation completion of 10, 20, and 30 years of service in a single cadre in absence of promotion. Therefore,
but they are promoted.
They are promoted.
Promoted when?
Promoted 36/2008.
Earlier period, how much?
Earlier period is from 2005 to 2008. In other post, that is the ex-cadre post. They chose to leave the earlier cadre. They chose to leave the earlier cadre, ex-cadre post, where no promotion was there, avenue was there. First,
they joined service which date, brother? They joined service on which date? Your client entered service which date?
Yes, ma'am. Just time. We all were appointed as remunerated copies. I'm placing the facts on remunerated.
Kindly tell us the date.
One line, because these are the facts required for the.
You will not say the date also.
Yes.
We are asking for the date.
2001, 13/2/2001.
1 second. All.
Name different 3 days. 1/8/2000, 1/8/2000, 13/2/2001, 14/9/2001, 10/10/2000. These are the 5 dates, my lord, on which
Paragraph 3 of the writ petition, Lordship, they have said. They have stated.
These are the date we have been appointed as remunerated copyist. Remunerated copyist is not a substantive post. That is only consolidated remuneration. Pays wise they are paid in this
for a copy.
Copy, yes, that is the post available in the High Court, remunerated copyist. But however,
your contention is that could not have a prospect of promotion, so there is no question of stagnation.
Yes.
And in lieu of stagnation, there can't be any advanced career progression.
Yes.
ACP, you can say.
That my lord, got it. So now, my lord, what happens for my
1 second. Avenue?
No provisional avenue.
No provisional avenue. Then where is the?
No, that just I am clarifying the facts, my lord. That is the movement. These first appointments in 2000, 2001, all these persons, we are on a remunerated basis. We are not concerned about that. I am not claiming against that appointment. What it has happened, my lord, they were brought over to the regular post of copyist, which is a substantive post in this honorable court.
On which date?
On Annexure 2, 39/2003.
All they brought over to regular. They were made regular employees.
Yes, regular scale also.
Regular scale, regular.
That is 3,050.
That's all right. Which date?
That is 39/2003.
30 September.
30/9/2003.
30 September 2003. Which is the next cadre for promotion?
There was no case of promotion for these copists.
Then where is the compensation?
What the honorable court has done. These copists, it is a substantive post till date. The post is functional.
Correct.
Post is functional.
Correct.
What they have stated in the impleading is the ex-cadre post, not like that.
No, assuming that you are holding the regular cadre.
The court has done on 36/2008, Annexure 3, 36/2008. All of them have been absorbed to the similar nature of job and similar nature of the scale. It is designated as junior assistant. Kindly see that order, man. Annexure 3, page 19.
No, you suggested. We believe you.
Why?
Should we not believe you?
Certainly.
This is land of Jagannath. People will not lie.
How will function?
Yes. No, our question is, as a matter of policy, this benefit is available to a stagnating employee on serving a particular block period, 10, 20, 30, provided that during the block period, he is not in a position to earn a promotion.
Correct.
But the post which you are holding, they do not have promotional avenue at all.
Yes.
Then how this policy is applicable?
So this policy is perfectly applicable to those type of employees where there is no question of promotion.
No.
Yes, ma'am.
Promotional opportunity should be available, but promotion should not be granted.
But the fact is, this is actually not the case, madam. But he has stated from the back.
We are asking you.
I am just clarifying. Yes, just madam.
Let us see the policy. Go to the case number.
Madam, let us.
We don't spend so much time.
No, that is why.
Because we come from service law background. At least, humbly we are saying
yes.
We need, these are not 2 minutes cases.
Yes, that is why let us clarify these two facts, because facts are jumbled up here. Let me clarify the fact. I will go to the policy.
You 2 minutes.
You 2 minutes, my lord.
Question is, we'll give you 20 minutes. But question is, take us to the policy first.
Yes, let us see. Page 23. Page 23.
Okay.
This is the government finance department resolution.
Correct.
On
now read first paragraph.
Yes. The state government considered the recommendation of the fitment committee and granted assured career progression (SCP) to the state government employees on completion of 15th, 25th, and 30th years of service, akin to the time-bound advancement provision of the Odisha Revised Scale of Pay Rule 1998. Accordingly, all state government employees avail SCP in 3 stages. That is, first SCP on completion of 15 years, second SCP after 25 years of service, and third SCP after 30 years of service in their original post/grade by its addition of 1 increment, that is 3% of the basic pay plus grade pay, with the next annual increment after a period of 1 year from the date sanction of the SCP. The Government of India in the meanwhile has introduced the Modified Assured Career Progression Scheme (MACP) for the central government civil employees in supersession of the provision of SCP scheme. Consequent upon implementation of the MACP by the Government of India, various service association of the state government employees have come up with the memorandum to consider implementation of the MACPs in respect of the employees of the state government, taking into account the uncertain promotional avenues and career stagnation of the state government employees. The government, after careful consideration, has been decided to implement the career advancement scheme to be known as Revised Assured Career Progression.
Where is that scheme?
That is the scheme. Where is that? Next part. Next page. There shall be 3 financial upgradation under the RACP counted from the direct entry grade
in absence of promotion.
The direct completion of 10, 20, 30 years of service on a single grade in absence of promotion. In absence of promotion. Yes, I'll come. Let me come to. I will stop here and I will clarify. Yes. If you are not getting a promotion on completion of 10, 20, 30 years of service, the employee concerned will get the RACP. Correct. What happened in this case? We are appointed as a remunerated copyist initially. That period is a very contractual. We are not going to that. We come into the mainstream on 36/2008 as copyist, which is a substantive post. While we are continuing as a copyist in the scale of pay, which is a bearing, my lord, that is 3,050 to 4,590, which is the similar and identical scale available to the post of junior clerk of this establishment. Now the High Court is 19 mechanism, Annexure 3. On 36/2008, the Honorable Court has what it done. The following 6 employees, copyists of the court are absorbed junior assistant in the scale of pay of rupees 3,050, the same scale of pay, 4,590, with scale allowance and admissible under the team with the date they joined their new segment. All these persons, 5%, 27.
What is the next promotion? What is the next promotion?
Yes, they have been absorbed as a junior assistant. The next promotion is senior clerk.
From 36/2008, they came to be absorbed
as junior assistant.
As junior assistant.
Yes. Now, my lord, next page. 29/4/2011. All they were given promotion to the post of senior assistant.
Absorption is 36/2008.
Yes. Initial appointment is 39/2003. As copyist.
As a junior
assistant. 36/2008. And we are promoted to the post of senior assistant on 29/4/2011, Annexure 4.
29/4/11.
2011. 29 April
2011.
Now, my lord, a change of policy came. What happened, my lord? The state government, because whatever the employees of the status of the employees, they are akin to the status of the in the secretariat. So the secretariat employees, those who are junior assistant and senior assistant, they were merged, and the policy has come in 2008, and they are redesignated as ASU, assistant section officer.
Your clients.
Yes.
No, other
secretariat employees.
Secretariat employees.
Yes. So therefore, the Odisha High Court ASUs, they come up to this honorable court, again a writ petition was filed, and order was passed, because as per 1949, when this High Court was established, there was a memorandum, MOP signed, there the court has said that whatever the pay scale, what are the posts there in the Odisha Secretariat, will be again scale of pay. Everything benefit will be same as the Odisha High Court employee. So this ASO was not given. So they came and a government, after this case was over, this Honorable Court has directed that all these persons will be treated as ASO, junior assistant or senior assistant. Because after merger, they will be ASO. The same benefit will be given to them. So in 2012, after this case was over, page annexure 5, page 21, 29/3/2011, government in the Home Department issued the resolution 2012. This junior assistant section.
29/3/2012.
Sorry.
29/3/2012.
The government has issued that resolution. Kindly see on page 21.
What happened in that resolution?
And yes, I'm just reading. Kindly see. Yes. The subject is merger of junior assistant and a senior assistant in the establishment of Odisha High Court with introduction of the new cadre of assistant section officer and redesignated of cadre of superintendent level 2, superintendent level 1 and section officer and superintendent respectively.
Correct.
Keeping in view the advancement in information technology in the administration of justice and also the fact that the employees of the Odisha High Court, which is the highest judicial wing of the state, maintain parity with that of the employees of the state secretariat, which is the highest office in the executive side. The proposal for merger of the junior assistant.
Come to para 2.
Yes,
After careful consideration, government has been pleased to decide.
Government has been decided that the existing cadre of the junior assistant and senior assistant in the establishment of the Odisha High Court shall be merged in newly introduced cadre of assistant section officer in the scale of pay so and so. The newly introduced cadre of assistant section officers shall be entitled to level cadre in the establishment of Odisha High Court. Entry level cadre of Odisha High Court. The existing cadre of the superintendent level 2, superintendent level 1 shall be redesignated section officer and superintendent respectively. The remuneration so and so. Then fourth is one. This will take effect from 30/9/2008. It has given a retrospect because that was the date on which Odisha Secretariat staffs were merged. This junior assistant section and senior assistant. Here now come back to the facts, ma'am. We were appointed as copyists on 30/9/2003.
Do you have short notes?
Sorry, my lord, I could not because I thought the last time that the order was they have to file some affidavit. I was impressed they would take some time. If my lord permit me, I will give you a short note. That will be easier, man. I feel that. Yes, I will give you.
It indicates clearly the dates.
Yes, dates are important. These are the facts.
In the form of a table where you have stagnated for 10 years, 20 years, 30 years.
Yes, I will give you.
And also don't hesitate to say that what they have given you. So that can be
I have given it.
No, in the table.
Oh, a table, yes.
Table, just mention.
What you have bought and what you want to get. So
yes.
And you circulate.
Will
so that both of you agree on the table and then we'll take it out.
Yes,
Then you will start disputing that this table is not correct.
I will give it to 1 week after so that I will prepare in the 2 weeks.
2 weeks.
So what affidavit you are supposed to file? So that's the order dated?
So after 6, I will order it.
17/3/2025.
No, 6th May.
But in last two occasions,
judge has rectified.
Last occasion they have taken time.
No, that's
That
all
will
right.
have fine.
That's all right. That's all right. Court employees there. Court employees. If we deny justice to the court employees, what impression they will tell to the public at large about us?
Justice should not be denied to anybody.
Anybody. That's true. More particularly, except judges.
That means below the land.
There is something. It's not that simple.
Yes, we'll prepare a date chapter. We'll come up your date.
Come up in the
Proper date. We'll also
both the sides to file a short and clear synopsis indicating the requisites. First, caller on which date you want?
Third of July.
Third of July.
About 7 matters.
After there, 10th of July.
10th. After exchanging the same with each other. Okay. Clients present before the court.
Yes. That
15 July, on which day both the sides are requested, both the parties are requested to be personally present before the court. All right.
Item 27.
Thank you.
Yes, brother.
I am appearing this morning. Incidence of performance under verification assistance scale.
5.7.
So Mr. Pada, now we have come to the other side. So this side. So what is the stand of the state with the Supreme Court?
A new rule has been introduced in the meantime. We have placed this new rule before the Supreme Court.
So you agree that to the investor's benefit, it can be discussed?
Yes, my lord. In view of that rule, now I am covered under old rule.
Yes.
So give the reference.
Yes. Kindly.
Both of you can furnish one copy.
How to apply for you? Apply consider first one pending application consider. Pending correct.
Verification
pending application will be considered.
Verification.
That is the section rule 2 below all pending application relating to death of government employee.
So start
Government employee occurred on or after in case the death of government employee occurred on or after commencement of 2016 rules 20 shall be governed by the provisions of the Odisha Civil Service Rehabilitation Assistance Rules 1990.
Let us see the 2020 rules. What has happened in that case? In 2020 rules.
No, Mr. Kutia, why should we record any rules and comment on that? Because
they not
left like that.
Not necessary, because I am saying that we were because of Rule 6(9) of 2020 rules. Now that has
suppose we say that the Rule 2B, if we quote it, yes, the 25 rules takes care of your grievance.
Yes, ma'am. Because their rejection is that.
So rejection was after coming into the new rule, they are not entitled to consideration.
So
this proviso is added now by amendment.
Yes, ma'am.
Which will take care of earlier cases.
Consideration. For consideration, there is.
That consideration will take place.
Yes.
We can record like this way. We're just giving the pattern of the order we are going to pass. Just think this. Both the sides having argued the matter agree that the case of the employee shall be considered in terms of Rule 2 as amended by notification dated 4th April 2025 within a period of 8 weeks.
Yes, ma'am. Only one made that they have rejected my case, you will also pass that order.
That will go.
Yes.
That will go. You are right. Afresh.
Reflect the name Odisha Civil Service Rehabilitation Assistance Amendment Rules 2025.
I'm not that familiar with the paperless codes and computer, and I never use computer. Petitioner is knocking at the doors of Red Board with the following prayers.
So Kutia, are you sure you have not filed the appeal here? You are not on the other side. Don't forget that. Be careful.
My read petition not on.
No, Ms. Patnaik is there. I marked her, but
no, this is read petition is not appeal.
No, even read petition you should avoid actually. Appearing for the other side now. If you have appeared in the read petition for the state, it's better you should not, Ms. Patnaik should appear. Continue to appear at that.
Some of the read copy of Mr.
It was there.
Yes, that's
Absolutely.
my
A coordinate bench of this court, wide order dated 3/8/2022, had said as an first. Next paragraph. Another coordinate bench, wide order dated 3/3/2025, said as under. Next paragraph. Be the above orders as they are. First off, both the sides in all fairness submit that now, while notification dated 4th April 2025, a suitable amendment is effected to the provisions of Rule 2 to Odisha Civil Services Rehabilitation Assistance, that is into brackets, rehabilitation assistance into brackets. Rules 2020. First up, amended the provision to Rule 6 of the said rules has the following text. Only A will do. Then just we have made the following text. Next paragraph. Learned counsel appearing for the petitioners submits that, and we agree with that. Submits, and we agree with that. That his client should be satisfied if their case is considered under the new legal regime as reflected in the subject notification. First term. Learned government advocate, AGA, additional government advocate, agrees that the case of the petitioner should be considered under the amended rules within a period of
3 months.
3 months. 3 months is very long.
No. Numerous applications are pending.
Within an outer limit of 3 months.
One application.
3 months. Although efforts should be made to decide within the said period as early as possible. First up, both the sides agree that all contentions need to be kept open for being treated by the competent authority under the amended provisions of the subject extant rules. First up, next paragraph. In view of the above, petition is disposed of.
That rejection of the fellowship.
First, it hardly needs to be stated that since the case would be considered afresh, all records that effected rejection of claim of the petitioners are hereby voided. Voided. Okay. No cause. Suppose, Mr. Ponda,
my lord,
you do not decide within 3 months. What should happen?
We may come for extension of time period.
No, that's something. That's another thing. Contempt. Again, one more contempt. Like this only time will be spent by these people.
No. I will ensure that it will be taken.
We will say in the event delay is cost. Every day you will pay rupees 1,000.
That person, that rider may be there, but that rider.
We make it clear that in the event matter is not decided as undertaken before us within the specified period, the competent authority who has to take the decision shall pay rupees 1,000. How many petitioners?
One.
To the 1,000 to the petitioner for delay of each day for the first 1 month and rupees 2,000 for the period next following. All right. This is the way. Otherwise, only case has to be filed and just the tamasha will go on. No. That's good. Yes.
Item 28. Item 28, two matters.
28, two matters.
Two matters are there, similar to this item 27.
Rehabilitation assistance.
Yes.
Yes. It is applicable to the employees working in judiciary also.
Yes.
Yes.
Same order. Same order.
That para 1, those orders your lordship quoted, those orders are not there in my end. That orders never. This is in the original side.
The subject matter of how many? 28, 29, 30? 28, 29. 28 having two matters. 28. The subject matter of these writ petitions are substantially similar to the one we treated in WP number
item 27.
15195/2022, whereby consensually reprieve has been granted as under. Yes, granted, first time. The relevant portion of the said order whereby relief has been accorded reads as under. First time. Next paragraph. Learned counsel for the petitioner submits that the like cases should be decided alike, and therefore whatever relief has been accorded to the petitioners in the cognate case has to be extended to his client as well, the arguable differences, if any, paling into insignificance. First up, we agree with this view, with this submission. First up, next paragraph. In the above circumstances, this petition is also disposed of, extending the same benefit to the petitioner, mutatis mutandis. Okay. Etc. Same will apply. Mutatis mutandis.
Keeping open, my lordship, any contingency, unforeseen circumstance.
You make application, we'll consider. Here, if we keep it now, you will definitely make an application.
Not there.
Officers, we know how government works.
I will.
No, not you. You mean not you. You are only the mouthpiece of your client.
I will come to reports. I will take change.
Government has to be proactive. It cannot work like a snail. Otherwise, all these cases arise because of the snail-like working of the government and governmental functionaries.
District judge.
District judge. In your case, it will be district judge. If it is district judge, it applies to them also.
27 also district.
Applies to district judges. All that will apply to district judge. It applies more to the district judge. Because they will not decide only. Yes. All. Can I take it, please? Yes, brother.
That the matter has come up for the first time, would like to take instructions. We have verified the Supreme Court case. To take instructions.
What is this matter about? Generally, we are against adjournment because we read after turning the pages. You are for the petitioner.
Yes, my lord, I am appearing for the petitioner.
Yes, you argue for admission. Let us see.
Yes, my lord. My lord, brief fact of the case is that.
Can I interpret?
But my lord,
because since we have a shortage of time usually, so let me. So how do you rely on that OMR sheet which you are comparing with the model answer?
Final answer.
Correct. How do I mean which OMR you have relied on?
Because my lord.
No.
Page.
Please, the answer. The question is very specific.
Yes, my lord.
You are saying that the OMR which you have answered, optical mark reader, which you have answered, you should get more mark.
Yes, my lord.
As per the answer key published by the
MTA.
So this OMR which you are now producing before the court to be the answer of the petitioner,
my lord.
Which is that you have obtained certified copy, you have obtained photocopy, or you have obtained the system of getting the exact copy?
Yes, my lord. It has been provided by the National Testing Agency at page 10, my lord. Kindly come to page 10.
Provided your OMR copy is provided to you.
In my website, in my email address.
It has been sent to you.
Yes, my lord. It is written there.
Page 8.
Page 10, my lord.
Page 10. Which are the questions?
To facilitate the candidates, scanned image of the OMR answer sheet has been sent on the registered email address given by the candidate at the time of registration of NEET 2025.
Which are the questions?
My lord, questions are, the petitioner appeared for 178 questions. Out of 178 questions, he has circled blackening the circle for the 173 and the questions.
173.
173 out of 178.
5 he has not.
He has correct the he has
he has marked stick marked.
No, man. Blackening the circle.
Blackening the circle.
Yes, man.
Okay. 173 he has done.
Yes, man.
Out of 178.
Out of 180, he has left 2 questions.
No, you said 173.
Total, my lord.
Total, how many questions?
180 total. 180.
All right. How many he has blackened?
178.
178.
Yes, ma'am.
Be sure you are saying 173, then 178.
No, 173 has corrected the answer.
They have valued the answers. 173 they have evaluated.
Yes, my lord.
That's what you are saying.
No, my lord.
Tell it in Oriya to my brother.
No, my lord. Kindly come to para 6. I have hour therein.
Para 6 of?
Para 6 of page 4. Read petition.
So, which is the page according to you? You have shown to the court that is the OMR sheet as per your answer. Which is that page, annexer?
Annexer?
Where is OMR sheet?
Two series, page 9. My lord. Page 9.
What is
This you have blackened.
Yes, my lord.
These you have blackened. One, right? According to you, what is your case? 1 second, please understand.
Sir.
Be kindly patient to us. There are totally 180 questions. Of them, 178 you have answered. Correct? What is your grievance? Any of the questions that have been answered, the answers given to the questions are not evaluated? Is it your case?
No, my lord.
No.
According to the official final answer key published by the National Testing Agency, it reveals that out of 180 questions, the petitioner attempted 178 questions.
You said that you said it twice.
Out of which 173 questions attempted by the
Kindly be attentive listening the question.
My lord.
So you say that you answered
178.
Answer 2.
178.
Answer 2, page 9. Look at your brief.
Yes, ma'am.
So that is your answer script?
Yes, ma'am.
You have got an email.
Pardon?
Yes,
you have got through email.
Yes, they give
Yes,
me.
But it doesn't show that it is attachment to any email. So that you have to first bring on record the email by which you have received.
My lord, it is clearly mentioned in page 10.
No. Mentioning that, kindly try to follow the question, sir.
Yes, my lord.
When you receive a email from in your registered email ID,
yes,
you have submitted to the NET, National Testing Authority, or whatever it's called, NTA, I think.
Yes, my lord.
You have to give that email copy, print out of that email. You can see it here also. I mean, so where is that? You have received it in your email. That's the first thing.
Number 3.
Because after
the meetings.
All these. How you
received all this?
The National Testing Agency has sent all the documents
to you
in my email address.
Where is that? That is what you have not stated.
It is page 10, wherein it is clearly stated that public notice 3rd June 2023.
Page 10. Page 10 is beyond your pleadings. Your pleading ends at page 7. My lordship asked you very specifically that either it is very simple. Yes, you don't have to even, suppose you have missed to state it also, then you could have enclosed the email copy. It is as simple as that. You take a printout and say annex the entire email copy, attested by whatever.
This is the procedure they have provided. They have said to facilitate the candidate, a scanned image of the
that you explain. In your case is that despite answering correct questions, you have not been marked or evaluated properly.
As per the answer.
So they have to be asked that. Our basis of asking them is to see, for us, for the court, to see your answer script sent by email, because this 10.
Yes,
because 10 itself says that it is sent
by the
it is sent.
Yes.
So on that, if they say that it is not sent or sent, that controversy arises. This court can go further. Neither you assert in your writ petition from pages 1 to 7, nor you enclose the writ email.
You are served with the copy.
Yes, my lord. At paragraph 4, I have asserted. I have affirmed that kindly come to page
read.
Paragraph 4. That it is proper place to mention that the NEET UG 2025 examination was held on date 4th May 2025. The petitioner appeared the test by putting his signature with left hand thumb impression and filled up the OMR sheet particulars and identified the answer in predefined checkboxes, which was duly signed by the invigilator mentioning time therein. The National Testing Agency has uploaded the provisional answer kits, scanned images of the petitioner OMR sheet, and recorded responses for the NEET UG 2025 on the website, so and so. Further, to facilitate the candidates, a scanned image of the OMR answer sheet having test booklet code number 45 has been sent on the registered email address of the petitioner.
You have not disclosed that even. What is your email ID?
Petitioner email ID,
For whom it will disclose that? It doesn't disclose to the court that I received my email in this ID.
Address.
So the problem is that We'll ask them this. It is as simple as that, he says that he has received because you have a clear-cut case.
Yes, ma'am.
Open and short.
Yes, ma'am.
Your answers have been wrong. But for that, you have to show what they have provided you as your answer script, because you do not have access otherwise. If it is uploaded, that's another thing. Uploading and sending by email are two different things. Uploading, I hope you understand. You go to the website, click it,
Yes,
and in a drop-down list, you are getting something.
It has been sent to petition.
But look at para 10, which my lord was just referring to.
Yes, ma'am.
To facilitate the candidates, a scanned image of the OMR answer sheet has been sent on the registered email address given by the candidate.
Yes, ma'am. At the time
of registration.
At the time
so it doesn't say regarding uploading. It says, and uploading becomes difficult because there are lakhs of candidates.
Yes, ma'am. So
you don't say that in your para 4 that in my email ID so and so. Can you show your application where you have disclosed your email ID, registered email ID where you have disclosed?
I will provide to the Honorable Court and tomorrow itself.
No, you have to support by affidavit.
Yes, madam.
You received the notice now.
Yes.
You have received. When did you receive?
This is for fresh admission was put up with them. Notice.
No notice was issued to you. Then we direct notice so they can answer all that. If he denies these things, then question arises. No, we have not understood the question. Which answer is wrong? Valuation of which answer is wrong according to you?
If the Lordship will take into account the final answer sheet, it is revealed that answer number 7.
You have secured 354.
As per the scorecard.
Out of 720.
Yes, my lord. As per the scorecard. But actually I have secured 687.
How?
As per the answer, OMR sheet and final answer key published by the NEET.
No. There are all objective type of questions and answers.
Yes, my lord.
Objective.
Yes, my lord.
Only tick marking.
ABCD. One, suppose
blackening. That's what. Anyway.
I have clearly indicated in my petition that which question was correct and which
now show which is our question. Sample cases you showed us. Show us sample cases.
For that, they have already published, so that is not disputed.
Yes, ma'am.
Are you disputing their answer key?
I have not disputed.
So exactly. So according to you, as per their answer key, your score is 400.
600.
So that 687, then discrepancy of 200 or 300.
354.
354 discrepancy.
Yes, ma'am.
So for that, you have to rely on your answer script. So your answer script at page 2, you are relying on.
No.
So this page 9 answer annexer, you have compared with your
final answer key.
Yes.
And I have mentioned very clearly.
No, mentioning, sir, it is now a question of looking at it.
Yes, madam.
You look at the answer. Page 13.
My lord,
did you find that?
Yes, my lord.
Which particular
answer is
1 to 180? You have been wrongly evaluated.
78.
Kindly come to pay.
No, please.
Yes, ma'am.
Is it your case that some of the blackening marks are not noted by the evaluator? Number 1. Is it your case that though you have given the right answer, you have not been awarded the marks? What is your case?
Though the petitioner has blackening the correct answer, it has not been evaluated taking into account the final answer key published by the National Testing Agency.
Which are those questions?
The questions are question number 7.
7.
7, yes, ma'am.
What is the question?
As per the OMR said, question 7, correct answer is
we know.
Correct answer is my lord 4. As per the final answer key published by the National Testing Agency, question number 7.
You ought to have secured how many marks? You have been given 1 mark.
No, for correct answer plus 4 marks. For incorrect answer minus 1 marks.
Oh, negative valuation is
Negative
also
valuation.
there.
Negative valuation.
Okay.
So, question number 7, instead of a final answer key shows that the proper answer will be 4. Answer 4.
Correct.
But I have, the petitioner has marked answer 1. It is incorrect answer.
Incorrect answer.
Yes, my lord. Similarly,
so incorrect answer will result into negative valuation
negative
of
minus 1, minus 1, my lord.
Correct.
So,
what they have done?
What they have done,
the
petitioner is not.
You take notice and come out with the true picture. All right. Are you served with a copy of the petition now?
Sir, answer the 7 is in fact you have marked 1.
I have marked 1. Petitioner marked.
Sir, are you following what you are presenting before the court?
Yes, madam.
You are saying answer 7 in the key is 4.
Correct answer.
Correct answer.
Yes, ma'am.
But you have marked it 1.
Incorrect, sir, my lord.
Yes.
Therefore, negative valuation.
Negative minus 1.
Yes. So what is the mistake then?
No. But the petitioner has put the blackening the circle for 5 questions, which will be incorrect.
5 questions.
Only 5 questions.
But they have said how many?
They have
not said how many at all.
No.
Yeah, whatever. Anyway, simple matter. See, there are 2 judgments. Therefore, I told you to gain entry to the library. There are 2-3 judgments of the apex court. Our interference is limited. Number 1, you have not challenged rightfulness of the key answers. Key answers are, you have taken them with face value. No challenge to them.
No, I have intimated the concerned functionaries challenging the wrong evaluation.
No, wrong evaluation is another.
Sir, can we follow? Because every time we are on a track, we are just veering off.
See,
because Lordship is asking that you have not challenged the answer key, or is it
kind?
Key answers are not put in challenge.
No, key answers are never challenged.
Not challenged. Number 1. Number 2, if key answers are not challenged, we have to take them as they are. Number 1. Number 2, out of 180 questions, according to you, your client has answered 178 questions.
Yes, ma'am.
Correct?
Yes, ma'am.
For these, out of these 178 questions, only 5 are wrong answers.
Yes, ma'am.
Is your answer? How many questions they have said are wrong according to them?
They have not intimated agent date. How much questions they have blackening?
We'll issue notice. Let them see. Take notice.
You are appearing for a National Testing Agency?
Yes. Issue emergent notice. First off, learned panel counsel. Who? You only? Panel counsel. Shri. Signed. So, on request accept notice.
Who is that?
Both D. Harithandan and ASGI.
ASGI. ASGI or DSG?
DSGI.
ASGI. DSGI. That's what. DSGI on request accepts notice for all respondents. For all respondents. First time, petitioner to serve a copy of paper book on the DSGI.
I have served the copies.
You have served already? Then that sentence may not finish. When will you call this?
2 weeks.
2 weeks.
Already council process started.
At earliest,
we'll call this matter on Monday. All right? Monday, all right? We'll call this Monday because the admission process and other things will be there now. Call on Monday, imminent. Okay. Good date.
My lord, I have
that day we will not give you time.
My lord, I have filed an IA.
IA for?
IA for opposite parties be directed not to conduct any counseling process till the disposal of the writ petition.
You want to hold them for ransack?
No, alternately, pray that a seat be reserved for the petitioner in his preferred college, considering his actual score as per his OMR sheet.
Let us see. On Monday, nothing will happen. On Monday, we will see. Okay? Monday. Okay. That day, if you do not come with preparation, interim order will follow. because he cannot be put to prejudice.
And it is on record. The same questions you have to answer. What?
Simple case it is. Simple case. Okay. 25. On the request of learned counsel, appearing for the answering respondent. Okay.
Two appeals.
I am appearing for the respondent solution.
What is this matter about? What is this matter about?
In fact, the jurisdiction of the State Consumer Dispute Mediation Commission, that was challenged before the Honorable Court. Honorable Single Judge held that in view of the judgment passed in UP Power Corporation and Odisha, that
Apex Court,
that consumer commissions have no jurisdiction on the issue involving one assessment proceeding made under Section 126 of Act 2003.
What is that? Assessment proceedings.
126 of Electricity Act 2003.
Assessment of electricity.
Yes. He was consuming unauthorized power that was detected. Assessment proceeding was initiated. That he challenged the same before the District Consumer Commission. District Consumer Commission rejected his application.
State Commission?
On the ground that referring UP Power Corporation on his the judgment of Honorable Appeals Court. Then he preferred an appeal to the State.
What State Commission said?
State Commission interfered, did not whisper anything about the judgment passed by the Honorable Appeals Court.
It reverted the order of the District Commission.
Yes. However, held that for de novo inquiry on de novo order passed to the final assessment.
Where is that judgment of the Apex Court?
And the other part, he has to go, he has a remedy of going to
Appellate Authority.
Appellate Authority.
Section 127 of Act 2000.
Alternate remedy.
That is the remedy.
Appellate Authority is available in Odisha?
Yes, yes.
Is the ombudsman or the?
No, that is the appellate deputy electrical inspector. That is.
Because
state government statutory.
Not only statutory. Expertise is
That judgment, Your Lordship, I am supplying 2 copies.
This first time it has come?
It has first time come.
Then it should be sensed. Issue emergent notice.
No, I am for the respondent. I have received the copy. Your Lord. Second time.
Presenting VC from Balasur.
I am for the appellant, my Lord.
Yes, sir.
I am for the appellate, and the division bench led by the Honorable Chief Justice has already been pleased to issue notice to the respondent.
They have appeared. They have appeared
now.
That is how he is arguing.
My Lord, this is a case of gross abuse and misuse of Section 126 of the Indian Electricity Act. And
Please read that section.
My Lord.
Electricity Act, na? What the section says?
I am going by the section 126, my Lord.
Please. No, it's not there.
My Lord, if on inspection of any place or premise or after inspection of the equipments, gadgets, machines, device found connected or used, or after inspection of records maintained by any person, the assessing officer comes to the conclusion that such person is indulging in unauthorized use of electricity, he shall provisionally assess to the best of his judgment the electricity charges payable by such person or by any other person benefited by such use. Clause 2. The order of provisional assessment shall be served upon the person in occupation.
We have understood now. The question is not that.
My argument is twofold. First of all, 126 is not applicable in my case for one of the several reasons I have stated in my grounds. And secondly, if around 126 is applicable, then the procedure under the very section has not been followed by the respondents.
Vishwan, since you are in VC, there will be a gap, some gap in your communication. But who will decide that 126 has been grossly abused
or not?
Or not? Who will decide that?
Whether it's the consumer forum or the statutory authority. That is the question posed to us now.
Yes, my Lord. That has been held by the Supreme Court Anish Ahmad case and the court, Supreme Court stated in its judgment, I am going back.
Not a consumer. Sir,
I am a consumer. I am a consumer both under the Consumer Protection Act and the Electricity Act.
All right, 1 second.
Which paragraph of Anish Ahmad favors you? Your submission?
My lord, pardon me?
Which paragraph of Anish Ahmad supports your
heading itself? Very heading itself. Unauthorized consumer of electric power is not
with the
a consumer.
Commission.
Simple.
It is not unauthorized, my lord. I am entitled to use 20% of the domestic use as commercial purpose.
1 second. 1 second. What do you say?
My lordship, I am placing the judgment of Honorable Apex Commission.
Apex Court.
Yes.
Which says a consumer.
Yes, that Consumer Commission has no jurisdiction on the issue of assessment initiated under Section 126 Act.
Who went to the Consumer Commission, District Commission?
The complainant. His
complainant went.
His claim.
Right.
The District Commission rejected his application.
Following 2013 judgment.
Judgment.
Okay.
Your lordship kindly glance. The question which was before this honorable whether complaints filed by the rest
paragraph 45 or no?
The first paragraph. First beginning, your lordship, question was there. Whether complaints filed by the respondents before the Consumer Forum constituted under the Consumer Protection Act 1986 were maintained. Whether the Consumer Commission has jurisdiction to entertain a complaint filed by a consumer or any person against the assessment made under Section 126 of Electricity Act 2003 or action taken under Section 135 to 140 of the Electricity Act 2000.
Very same section is considered.
Exactly. Your lordship, I have really long judgment. Your lordship, para 30.
1 second. 1 second. He cannot listen to. Let us see what he says. Now, what is the difficulty in going before the appellate authority? We will give you time, and till they will not precipitate the matter, you approach the appellate authority. We will give you time also.
My lord, that is not an issue. The issue is I have not been given an opportunity of hearing.
I have not giving you opportunity. You convinced that you are a consumer.
Exactly, my lord. The principle of natural justice has been violated.
Yes, number one.
How can I approach the appellate authority? I was constrained to approach the district forum.
1 second. One is principles of natural justice violated. Second ground.
Second ground, unless there is a copy, how can I approach the first appellate authority? That is the Section 126, my lord, reads that the copy of the assessment must be supplied to the person in occupation.
Right. We will see that it is supplied to you.
That copy has not been deliberately not supplied.
Copy will be supplied to you. Second is over. Third.
Our point is the final assessment has not been made within the statutory period of 30 days.
Your limitation.
That copy has also not been served on the appellate.
All right. Next.
Finally, the jurisdiction of the Consumer Court has not been completely ousted by the Supreme Court. Instead, the Supreme Court held that when there is a dispute between the Consumer Protection Act and the Electricity Act, then the Consumer Protection Act will prevail. That is at 47 of the Anish Ahmad case.
Take down.
47 of your lordship, that judgment will kindly have.
All right. Give the question. Petitioner, the appellant, this intra-court appeal seeks to call in question a learned single judge's order.
Yes, sir.
Single judge's order dated 24/7/2024 entered in consumers WP number 15399 of 2024.
License.
Respondents appeal WP number 15399 of 2024. First of all, A brief fact matrix of the case is as under. 1. There was a dispute as to excessive or unauthorized consumption of electric power. Be seated. Be seated. What you written now? Unauthorized consumption of electric power. First off, matter went to the district commission, which negatived the dispute, holding that a person who is alleged to have made unauthorized consumption of power does not answer the definition of consumer as provided under the under section 2 of so and so of the Consumer Protection Act, so and so. First up, this was in the light of Apex Court decision in UP Power Corporation Limited versus what is that? Versus Anis Ahmed, 2013 SC 2766. Personal. Matter was carried in appeal to the State Consumer Redressal Commission by the consumer, and appeal came to be allowed by the allowed. First off, this was put in challenge before the learned single judge, who has reversed the said order, eventually resulting into the appeal at hands. First off, next paragraph. Learned counsel appearing for the appellant urged the following grounds for invalidation of impugned order of the learned single judge. Roman paragraphs 1, 2, 3, 4, that. There is a gross violation of principles of natural justice, which are part of Article 14 of the Constitution of India, as held by the Apex Court in a category of decisions, and therefore the impugned order is liable to be set at naught. Number 2, the answering respondent has not supplied copy of the order nor the final order relatable to the proceedings held under section 126 of the Electricity Act, so and so. State Electricity Act? No, Electricity 2003.
No, the Electricity Act 2003.
2003. And therefore, without that order, the appellant is put to prejudice. This aspect of the matter has been lost sight of by the learned single judge. 3. The law prescribes a period of limitation for taking up the proceedings under section 126 of the 2003 Act, and after the expiry thereof, the proceedings could not have been initiated and accomplished. First up. Next paragraph. Learned, are you panel counsel? Learned panel counsel representing the answering respondents opposes the appeal, making submission in justification of the impugned order, placing heavy reliance on the decision of Apex Court in Anis Ahmed case. First off, he also submits that a separate appellate authority having expertise in the matter is constituted under the 2003 Act, and therefore a matter involving specialities and expertise like this cannot be adjudicated upon by the consumer fora established under the Consumer Protection Act. Which year?
2019.
2019. First up, he also points out
86.
86 that
is a reenacted.
19 came into.
He also points out ordinarily in matters like this, the special forum has to be approached if there is any grievance. First up, next paragraph. Having heard the learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter for the following reasons. Number one, the contention that there is a gross breach of principles of natural justice, and therefore the learned single judge, regardless of availability of alternate forum, ought to have and granted redressal to the grievance of the appellant is bit difficult to countenance. Semicolon. Ordinarily, the jurisdiction of the constitutional courts is not permitted to be invoked when there is an alternate and equally efficacious remedy available at the hands of a special tribunal or authority constituted under the statute which governs the subject matter, namely 2003 Act. First of all, the related contention that when remedy is available under two regimes of law, the consumer forum ought to have consumer forum has rightly decided the matter, alternate remedy notwithstanding, is bit difficult to countenance. First up, next paragraph. The very question whether a person who unauthorizedly draws electric power would answer the definition of consumer as given under Section 2 of 2019 Act had fallen for consideration of the apex court of the country in Anis Ahmed Supra, and it was answered in the negative. First up, that one of the jurisdictional facts for invoking the jurisdiction powers of consumer forum is that the invoker should be a consumer. First up, without jurisdictional facts, the district consumer forum had rightly denied relief to the appellant herein. First of all, that could not have been upset by the state forum, that too without referring to law declared by the apex court, which binds everybody in terms of mandate enacted in Article 141 of the Constitution of India. First up, what is the next point? Next point. The other contention that the appellant was not supplied with copies of proceedings taken under Section 126 of the 2003 Act not much impresses, in as much as he was before the consumer forum, and therefore he could have been before the statutory authority instead. First up, We do not subscribe to the view that in every case of complaint, there has to be a positive order. First off, various high courts in the country have taken the view that even without a positive order, the grievance can be made out before the special statutory authorities like the District Consumer Forum and the State Forum, as the case may be. First off. Next, the last contention that the proceedings against the appellant herein were hopelessly time-barred, and therefore no indulgence could have been granted by the learned single judge by upsetting order of the State Consumer Forum does not merit acceptance. First, limitation. All authors on the law of limitation, including summoned in jurisprudence, says is a mixed question of law and facts. First off, when such questions are involved, the proper remedy is to be obtained at the hands of statutory authority. First off, Basu on constitutional law has given a cartload of citations as to denial of remedy by the writ court when special statute provides the machinery for availment. First off, we need not reproduce the same because that would only bulken the judgment which we are dictating now. First off, next paragraph. All the above being said, the petitioner the appellant cannot be sent empty-handed by quoting some theories of law. First off, it was Justice Oliver Wendell Holmes of the US Supreme Court who said the constitutions are meant for maintaining the practical rights of the citizens and not for denying them by quoting jurisprudential theories in Twain versus Swain. First off, that applies here also. Since we are non-suiting the appellant on the ground of, mainly on the ground of availability of alternate remedy, we in the above circumstances make the following order. First off, the writ petition, the writ appeal is negative. Second, the appellant is granted a period of 4 weeks to approach the statutory authority for the redressal of his grievance, taking up all contentions available in law. Second, for a period of 4 weeks, no coercive proceeding shall be taken up against the appellant. First off, contentions to the other side are also kept open. First off, in the circumstances, courts may be easy.
May I just submit one thing, my lord?
Yes.
Because of forum, that is commission.
Commission.
Yes.
Whichever.
Forum, that is commission.
Whichever is the statutory commission.
My lord, correct address of the appellate authority must be provided.
Now, earlier forum have been designated as commissions. Forum is commission, state is also commission.
The second thing, my lord, during the subsistence.
Consumer Commission. District Consumer Commission, state, that accordingly you have to make that change. In your state that way. In the act itself it is said. I am not good in consumer protection except one or two.
No. Lordship said state forum and district forum. Both are now commission.
Both are commissions. The district commission, and just look into that one. Okay. Thank you for correcting me. Yes.
My lord, one more thing, my lord.
Yes.
One more thing.
Yes.
During the subsistence of the State Consumer Commission's order, and the commission specifically directed not to take any coercive action against the consumer, they disconnected my power supply. That is, my fundamental right to electricity has been violated, which is a case of jurisdiction of this honorable court, my lord.
The person who has misused the power, he is not a consumer. Therefore, we said no coercive action will be taken against you. That we have said. Beyond that, we may be
Already,
then we can be
my
rectified.
right has already been violated in 3.
Next.
34.
This is, I'm appealing for there are 4 appeals, my lord. I am in the appellant in the first 2 appeals and respondent in the last 2 appeals.
There are 4 appeals.
4 appeals.
So we will have a big catch of fish today.
Today appearing for the last 2 appeals where I am the respondent along with senior advocate Mr. Jakir. Lordship kindly be taken up on 8th or 9th of July so that we'll file a short affidavit.
Short affidavit you want to file? What is that affidavit?
That after some developments have been taking place in the meantime, it was filed long back in 2000.
All right. Call after 3 weeks at the request of the council appearing for.
I may pray a date may be fixed because I'm for the college and I'm in the appellant in the 4th sub-item, my lord. Your lordship, a college is stuck, no admission.
Whichever date you want to choose.
8th,
we have posted already 3 matters.
9th.
After 3 weeks.
After 3 weeks you can.
15th, your lordship.
15th we can have.
Yes.
2 matters we have posted on 15th. All right. Call this matter along with on 15th of July 2025 as unanimously requested at the bar. Okay. That date again you can't say that senior advocate is not available, etc. You have to read, you have to just argue the matter. We will not spend time that way. You have prepared the memo now?
Yes.
Barkadi. Both the
sign with the identity.
both are in appeal.
Both in the other.
Item.
Both, could you try this? Where are the signatures of parties?
Signature of the parties is identified with the.
There is no beauty.
Madam.
No beauty. Object of life is to move from truth to beauty. Satyam, Shivam, Sundaram. Sundaram is at a higher pedestal. Make it beautiful. All right. We'll pass this order. We'll get it typographed.
Yes.
Get the signature of the parties and your signature also.
You have written a copy?
Yes, we have taken
I mean, in the phone. In the phone you have copied it. Okay. Then they have a copy.
They have copy also.
Yes.
Then they can, you type it out?
Yes.
You want to type it out?
Yes. In course of the day, we'll find.
Both the sides very appreciably have entered into an amicable settlement and placed it in writing in the form of a memo with the signatures of the parties and their own. The memo reads as under. Next paragraph. We have perused the appeal papers as also the terms of settlement now put forth before the court in the form of above memo. First off, these terms appear to be reasonable and just. First off, parties are also present before the court.
Colleges and institutions of radiology department.
Radiology department?
Yes. Challenging the arbitrary action of the opposite parties.
What is that action?
Yes. Government of Orissa published notification under Annexure 2, my lord, to initiate a training program, ECPN.
Preconception, prenatal diagnostic techniques.
Yes,
my.
Guidelines also issued by the government for 6 months training in ultrasonography, fundamentals of abdominopelvic level 1 for MBBS, PG, MS, MD, DNB doctors under Annexure 1.
If they are specialized in radiology, they must be PG students.
Yes, ma'am.
All their PG.
Yes, ma'am. The entire admitted fact is that, my lord, there is insufficient faculty in medical colleges of PG students in Odisha for which
The MNC also issued strict judgment
About
to
that.
state government. To state government and DMT also. They have filed their counter filed by the state in page 6, para 11. My point is, my lord, despite such admitted shortage of faculties, the opposite party, that is DMT, initiating training programs, depriving the petitioners as well as the trainees.
The quality of training will be affected.
Yes.
Quantum and quality of the training will be affected.
The specialization course of the PG students and the trainees also affected. Under
how it is affected?
Minor, because suppose they are to be given training in A, B, C, D faculties.
How big are the doctors in this country?
Voluntary Health Association of Punjab versus Union of India. I have also a judgment of
Half-baked doctors in the country.
Yes, my lord, that's also an omen.
If that is so, what is the what are the steps you have taken to provide members of the faculty who would impart training to these people?
My lord, we have already tried to get doctors appointed through OPSC, which are the vacancies are there.
What are the efforts you have made? Just tell us.
Yes, my lord.
What are the efforts you have made? What are the steps and timeline of the steps?
Yes.
When did you take? Have you stated in your affidavit?
Yes, my lord. My counter.
Take
2 to 12.
Affidavit is dated?
Dated 10/9/2024, my lord.
10/9/24.
Page 81 of the RIP.
Now, what are the steps you have taken?
That
paragraph
9, my lord. We have given this status. What are the vacancies there and what are the posts are there? Then para 10, my lord.
The tabular column.
Yes, my lord.
Next. Go to 10. 1 second. These are, in this regard, details of faculty says as under. You agree that the number of hands are missing?
Yes, my lord. Because throughout India also for radiology, these teachers are not there. And but we are managing with them, and there is no complaint from the trainings or the student.
I think the court's concern, Mr. Khandatra, is that you are recommending the vacancies to be filled up to the OPSC.
Yes, my lord.
The process is regularly done.
Yes, my lord.
Regular recruitment is done.
Yes, my lord.
So you have to show that. You have
Show that. What is the vacancy position? What is the vacancy filling?
Fill it up.
Yes, my lord.
How many you have filled up?
My lord.
In what period?
Next, sir. A1, my counter, my lord.
Six. Next, please.
One second. Please, para 10. If the submitted all the 19 centers of approved and completed training center with government of Orissa, so has not been overlooked. Further, it has been strategically integrated into our existing faculty and equipment sources for bringing more awareness into the society for thereby filling the gap of required trade terminologies to improve qualities. And no, these are only sentences. Very beautifully drafted. Maybe the draftsman has read Wren and Martin on grammar, English grammar, but that will not help us. What is the sanction strength? Next.
Scroll କରନ୍ତୁ ତ
all the medical page 7 my lord of my counter.
Just give us a moment.
Same, his counter, my counter is somewhat same because government counter.
No, there is shortage of faculties in medical colleges across the country due to various reasons. A parliamentary panel, so and so, that form. You admit that faculties are short.
Yes, my lord.
Then what should be done?
My lord, we have given direction for fill up of those posts to OPSC.
You means whom you represent?
This DMT has written to the government has written to the
who appears for the government?
Government.
You appear for the government.
My lord.
What the government is doing?
My lord, we're taking steps to fill up my lord.
Show that what steps you have taken.
So, page 3, internal page 3 of my counter, my lord.
What are the steps? Read.
Your counter is one.
OP1.
Now you answer pointed questions.
My lord.
What is the faculty sanction strength?
My lord, the annexure A1, my lord.
I do not want your annexures.
My lord, there are different medical colleges and different vacancies are also there, my lord. Page 7, my lord.
Annexure 1.
There are 14, my lord. Page 7. My counter. Opposite but not
all right. One general question we are asking you now.
My lord.
How many totally integrated? How many? What is the sanction strength? And what is the shortfall?
Well, the total sanction strength is 1,053, my lord.
1,053.
Yes.
As against this, how many hands are working?
888. 888, my lord.
888.
Yes. And the vacancy is 165.
165. Vacancy
165. 165. What are you going to do with the 165 vacancy now? Is it correct? Vacancy position.
Because in annexure A by
we are asking you, is it correct or not? It admits a binary answer.
Assistant professor.
They are assistant professors.
Yes, ma'am.
There are various other professors.
Yes.
Associated professors.
Yes,
professors emeritus.
Yes, ma'am.
But other posts are promotional. There is no direct recruitment for associate and professor.
But still they have to.
Then you have to show, as it fell from my lord, that you are holding regular promotions. DPC. Regular DPC promoted.
And my lord, also to fill up the vacancy, contractual engagements are there also.
So you keep your principal secretary. Who is the principal secretary of the department?
Health and Family Welfare Department.
Health and Family Welfare. Keep him present before the court. When these vacancies arose,
my lord,
which date each of the vacancies arose?
That details is not with me, my lord.
Then what should you do with your objection statement? You have to give when each of the vacancies arose. What steps you have taken for filling up of the vacancies?
Right.
You can't just say all over the country there are thieves and therefore there are thieves in our state also. That does not convince us. You have to take steps periodically. Steps have to be taken for periodic appointments. Since those steps are not taken, these problems have arisen. And the radiology is considered to be the very option of demand. It depends upon radiological things. Not everything radiology nowadays. Therefore, unless they undergo the training at the hands of all these faculties, the training will be incomplete. You ask your secretary to come and explain everything. When do you want your secretary? We'll make an order now. Or you want to bring more material?
More material. My lord,
you are appearing for?
I am appearing for DMT, who is Director of Medical Education and Training.
Director of Medical Education.
Yes,
Where you keep your clients before the court. Principal secretary should be here. Your director should be here.
Yes, ma'am.
They can't play with the lives of the people, havoc. They can't take, people are not like just, these problems arise because you are not providing proper training.
My lord, I want to just disturb. The 7th batch of training has been over and this training they have challenged. That is over since December 27.
That's all right. But
for
you
the
want to,
future.
the next batch, if it comes, same thing will happen.
Yes. That's what we want.
Then we will not leave this matter that way.
No. That's what they should be very much particular about the next trainings to be done.
No, but you have to tell what action, plan of action we need.
Yes.
On which these are the vacancies in assistant professor, professor emeritus, associate professor. These are the vacancies. We are calling for the application for appointment on such and such date. And the interview will be held on such and such date. Appointment orders will be issued. That plan of action we need.
Yes, my lord.
Not cock and bull story.
Yes, my lord. That's what I have given in my counter.
Where have you stated?
My lord.
Tell. You are not the appointing authority. You are only a director.
Yes, my lord.
You are only a glorified big man there. You are not the appointing authority. Appointing authority is the government.
Yes, my lord.
Therefore, government has to make a statement when you are going to take steps. We will not go by what your director will say. Who is that director? Much below the government level. Policy, who is the appointing authority? He should say here that we are going to take these steps. Keep your secretary present. Matter was heard for some time. It involves certain questions of immense importance to the public health system. First off, in view of that, the Principal Secretary, Health and Family Welfare Department of the Government of Orissa and the Director of
Medical Education and Training.
Medical Education and Training
Odisha
shall be are requested to be personally present before the court to explain as to the steps they have taken to make good the vacancies, long-standing vacancies in the vacancies in the training faculties departments. Call this matter on. It is very clear. First off, they should come with full preparation and also sworn to affidavit at their hands in this connection. First off, learned panel counsel appearing for the director and the learned AGA, ASC appearing for the government shall brief these officials so that they shall come with full preparation. Okay, you have to tell them.
Yes, ma'am.
But all discussion and also about the discussion, long discussion that took place in the court hall.
That's available nowadays.
Of course. What's it? It's available on this only. Yeah. Call on. Which date you want?
23rd.
27. Why 27? 23rd. All right. 23rd. Okay? And serve a copy of that affidavit in advance on madam.
Yes, ma'am.
All right. Yes. Copy of the affidavit in contemplation shall be served on the learned counsel appearing for the petitioners. Yes. Yes, sir. Yes, sir.
Case, my lords. The rejection of admission. I would put it this way: non-approval of the admission.
Non-approval of admission. Admissions were already done. Who should approve the admission?
The government, central government does not approve the admission.
Who is the approval authority?
NEET, the National Council of this medicine.
Indian System of Petition.
Indian system. I'm sorry. Thanks. Grateful to you.
Ayush Department.
Ayush Department. Now, what has happened here, my lords? The facts.
They are the approving authority. OP1, they are.
OP1. OP1 is the approval.
Admissions to which course they are?
BAMS.
BAMS. The Ayurvedic medicine. Medicine system.
My learners are here. This is varied. I say one thing. Today, I have filed the counter and served a copy on them. Yet I have not received the hard copy. I have submitted within 3 days. And you will also the OP number 2 and 3, the college. They have taken admission on management quota, and as it goes against the rules, that guides the field of admission because he has secured less than 50% percentile.
You want to argue the matter, or you want to
I just want Monday, if you also set and a copy of the counter of opinion number 2 and 3 maybe
counter
2 and 3. My lord, serious for petitioner. 2 and 3 not there.
2 and 3, who is the nobody's
Mr. Sahoo. Upinder Sambar.
Yes, sir.
So he took leave because he is arguing before
Yes. That's why he is
election petition.
Yes, that's why he's not there. That's why he just mentioned.
After 1.5
But they have filed counter.
Yes, sir, they filed counter.
Short counter.
Your counter is e-filed. You have to reach us.
I have not received. My count also, I have already given the copy.
When did you file your count?
No, sir, I filed today.
So it's e-filed, so not reached us.
Yes. The Monday, you can also give that both the counters
you can finally hear it on Monday, but just to place the facts in perspective.
May not be necessary. On Monday you can do that. Otherwise, I just waste some more time. Call this matter on Monday as requested at the bar. First time. In the meanwhile, pleading shall be completed, if any, after serving copies on the respective counsel representing the parties. Okay. Next.
It has an interim direction that will continue.
Interim order as obtaining this date shall continue till next date of hearing.
We are taking steps. We are taking steps to resolve the dispute between the parties.
Yes, government was appeal against was not exactly acquittal, but enhancement of sentence.
Enhancement of sentence.
They were the accused persons who were the opposite parties here not respondents. They were tried for the offense under section 302 IPC laws.
Two 2003 matter.
Yes.
22 years.
They have served their part of sentence. They have already served.
So they were convicted for 3 years. They underwent.
What is the offense?
Offense was they were tried under section 302, but they were convicted under section 304.
304.
Yes.
Part 2.
Not part 2, only 304.
304.
Yes. So 3 years they underwent the sentence.
So minimum is less than 7 years.
I think that is not so. Here, what has happened? Now I have come up because your lordships were pleased to issue warrant of arrest against the respondent number 7, who did not, because at the very outset, when your lordships were pleased to sanction the leave and admitted the appeal, your lordship directed them to be released on bail by the trial court. The president appellant respondent was not aware of the fact, could not avail that benefit. So lordships were now in 2024, I think, were pleased to issue NBW. On the basis of the NBW, he has already been taken into custody and he is there for more than 1 month. So now I prayed for lordship will direct him to release on bail and also you can take up the appeal for hearing.
Petition you have filed?
Yes, that is IA number 4 of 2025.
Unusual order.
They have not. No, my lord.
Well, brother appears to be unusual, Lord.
Yes, my lord, but they have not appeared for years together, my lord, before
How
this.
they can secretary present.
Sir, Khandayatra appeared where?
Before this honorable court, my lord. Several notices have been issued, my lord. Not certain.
Where? After grant of leave only that it becomes an appeal.
Yes, my lord.
So by serving the sentence, they did a mistake.
Prior to that, my lord.
Not prior to that. So let us not change the discussion. At times where what we are doing, we are starting discussing so many things. The issue is they were awarded a sentence.
Yes, sir.
Yes, they served it.
Sir.
When the leave was granted?
3 persons are murdered, my lord.
Sir, emotive. Emotive. that whenever three persons are murdered, there has to be a conviction. You have read that as a Privy Council, that
My lord, famous judgment.
famous judgment. So we are not discussing
on merits.
Lordship, but the bail is also lordship can consider the copy of I but not ship my lord. Lordship,
I have given this already in office.
I
I will give one copy, but I have served in his office.
One more, give one.
Right now I can give it.
I recorded name.
I can go on. I can give you 4 copies. No problem.
You can see his copy.
I can give him 4 copies. We are getting Xerox.
One copy is sufficient.
It is plus usual practice we serve in the office of the advocate.
Sometimes they are yes, sir.
The IA number 4 of 2025, the IA has been filed for granting bail to the respondent number 7, who has been arrested pursuant to the order passed by the coordinate bench dated 5/5/2025. It is submitted by the learned Mr. Samantrai. Mr. Samantrai, learned counsel for the respondents.
No, I am appearing for 7 only.
Only 7.
Yes.
7 appearing for the respondent 7. That he was arrested on 21st of May 2025, produced before the trial court and sent to judicial custody.
Yes. Bail was rejected by the learned trial court.
And bail was rejected by the learned trial court in view of the order passed by this court. The brief facts of the brief background fact leading to the arrest of the respondent is that the government in this has been converted.
Yes, converted to jail criminal. Government criminal.
In this present appeal challenges the order of conviction and sentence passed by the second additional session judge Berhampur in SC number 9 of 1998. SC 112 of 1998.
19. GDC inadequacy of
only regarding inadequacy of sentence imposed. In considered view of this court, the grounds taken by the maximum discretion is given
our relation. We have served these sentences.
In considered opinion of this court, since the respondent has already served the sentence, he shall be released on bail forthwith on the terms and conditions that would be deemed fit and proper by the learned trial court. The learned trial court shall act upon production of the website copy of this order.
No, so you said 9 of 92, part 5, because the original record has been called for.
Lost or here?
No, here it has been called for by your lordship. Because he has also said page 5 of that.
Just kindly write it in a piece of paper.
No, it is there. No, in page 5 of my IA, at the top, the
page 5 top of the.
Yes.
SC 9 of 1998 into bracket part 5. PF is part
5.
Just reproduce whatever is written in prayer column. The IA starts disclosing. Yes. Yes, any date you want? When do you want?
Because the notice has been, fresh notice has been issued to minutes 1 to 6, 8, 9. They have to appear. But they, whether they have taken steps for the issuance notice, I do not know, minutes.
1 has died, 10 has died.
10 has died, 10 has
abated. So
you take steps. By the next state, appellate states shall take the steps for sufficient for serving of notice of the respondents. I'm not giving any date.
Let service happen.
He's saying July, but next Monday is 30th.
Yes.
Instead of second, we can have one.
8th of July?
8th of July 1, 9th of July 1, 10th of July.
That way.
That way.
Okay.
The better spread it.
One is the restitution of conjugal rights. That's all.
I'm for this one.
Come with the full preparation that Sarita Venkata Subbarao is diluted to a great extent. Just look into that judgment. The other day, one of your members of the bar told that in 2024 there is a judgment which refers to Sarita Venkata Subbarao. All right.
My lord, item 45, my lord.
45.
Item, my lord, only 4 days delay. That was common hearing, my lord. Item 45, my lord.
45. MATA 419.
On the date state will condone the delay, but you both of you be prepared.
Prepare for the final hearing, my lord.
It has been listed for hearing also.
Yes.
But
that has not been condoned. That's why.
Because it is tagged to this has been.
Because
Mr. Mahathir,
you condone that delay. Delay standard format. Last one.
MATA 446. IA is 575.
You have seen 43 indicated assignments.
Yes. All 3 matters are in the list, starting with 8th July, 9th July, and 10th July.
Okay.